Chapter 7. Bankruptcy is a legal tool that can help people who are struggling with overwhelming debt. Think of it as, well, a fresh start. When you file for Chapter 7, you ask a court to wipe away or discharge many of your debts. This process is often called liquidation bankruptcy. That is because a court-appointed person called a trustee might sell some of your property to pay back your creditors. However, many people who file for Chapter 7 do not lose any property. This is because laws called exemptions protect essential things like your home, car, and personal belongings up to a certain value. Filing for bankruptcy is a serious decision, but it can provide significant relief for those who can no longer manage their financial obligations. Not everyone can file for Chapter 7 bankruptcy. The law has rules to make sure only people who truly need it can use this option. The main test is called the means test. This test looks at your income and compares it to the median income for a family of your size in your state. If your income is lower than the median, you will likely qualify. If your income is higher, you might still be able to file, but the calculation becomes more complex. It will look at your income and subtract your necessary living expenses. The goal is to see if you have enough disposable income to pay back a portion of your debts through a different type of bankruptcy, like Chapter 13. Besides the means test, there are other requirements you must meet. You must complete a credit counseling course from an approved agency within 180 days before you file your case. This course is designed to help you look at your financial situation and explore all your options. The court wants to be sure that you have considered alternatives to bankruptcy before taking this big step. You also cannot have had a previous Chapter 7 case dismissed within the last 180 days for certain reasons, such as failing to follow court orders. It is important to understand these rules to see if Chapter 7 is the right path for you and to ensure your case proceeds smoothly without any initial problems. Deciding to file for bankruptcy is a personal choice that depends on your unique circumstances. It is often a good option for people with a lot of unsecured debt like credit card bills, medical bills, and personal loans. These are the types of debts that Chapter 7 is very effective at eliminating. On the other hand, it does not typically wipe out debts like child support, alimony, most student loans, or recent tax debts. Understanding which debts can and cannot be discharged is a critical part of the decision-making process. Carefully reviewing your financial situation and the types of debts you owe will help you determine if filing for Chapter 7 will provide the fresh start you are looking for. Before you can officially start your Chapter 7 bankruptcy case, you need to gather a lot of paperwork. The court needs a complete and honest picture of your financial life. This part of the process can take some time, so it is best to be organized from the very beginning. You will need documents that show your income for the last 6 months, such as pay stubs or other proof of earnings. You will also need your most recent federal tax returns. It is also important to find statements for all of your bank accounts, retirement accounts, and any other investments you might have. This information will be used to fill out the official bankruptcy forms accurately. In addition to your income and asset information, you will need to create a comprehensive list of all your debts. This means gathering bills and statements from every single creditor you owe money to. This includes credit card companies, hospitals, doctors, personal lenders, and anyone else. You will need their names, addresses, and the amount you owe to each one. You also need to make a list of all your property. This includes your house, cars, furniture, electronics, clothing, and anything else of value. For each item, you will need to estimate its current resale value, not what you originally paid for it. Being thorough is very important because you must list everything you owe and everything you own. Once you have all your documents, the next step is to fill out the official bankruptcy petition and schedules. These forms are quite long and ask for detailed information about your finances. You will use the documents you gathered to complete them. It is crucial to be completely honest and accurate on these forms. Hiding assets or debts is a serious offense that can lead to your case being dismissed or even criminal charges. Take your time and double-check every entry. Many of the forms require you to list your monthly income and expenses, so having your recent bills and pay stubs handy will make this task much easier and more precise. After all the forms are filled out, you are ready to file your case with the federal bankruptcy court in your area. You will need to pay a filing fee when you submit your paperwork. If you cannot afford the fee, you can ask the court to let you pay it in installments or even waive it completely if your income is very low. When you file, you must also include the certificate from your pre-bankruptcy credit counseling course. Once your case is filed, an automatic stay goes into effect immediately. This is a court order that stops most of your creditors from trying to collect money from you. It stops wage garnishments, lawsuits, and harassing phone calls. After your Chapter 7 bankruptcy case is filed, the court appoints a bankruptcy trustee. The trustee is not a judge, but an official responsible for overseeing your case. Their main job is to review your paperwork to make sure everything is accurate and complete. They will also look at the property you own to see if there are any non-exempt assets. These are items that are not protected by exemption laws and could be sold to pay your creditors. The trustee will carefully check your lists of assets, debts, income, and expenses. They may ask you for additional documents like bank statements or vehicle titles to verify the information you provided in your petition. About a month after you file, you will be required to attend a mandatory court hearing called the 341 Meeting of Creditors. Despite its name, creditors rarely show up to this meeting. The primary purpose is for the trustee to ask you questions under oath. You will need to bring your government-issued photo ID and proof of your social security number. The trustee will ask you to confirm that the information in your bankruptcy forms is true and correct. They might ask questions about your property, your debts, or any large financial transactions you made before filing. The meeting is usually brief, often lasting only 10 or 15 minutes. Preparing for the 341 meeting is straightforward, but it is important to take it seriously. Before the hearing, you should review the bankruptcy petition and schedules you filed. Make sure you remember and understand the information you provided. It is essential to be honest and direct when answering the trustee's questions. If you do not know an answer, it is okay to say so. Do not guess or provide information you are unsure about. Your attorney, if you have one, will be there with you to help you through the process. Being prepared and truthful will help the meeting go smoothly and avoid any potential problems or delays in your case. After the 341 meeting, you have one more important task to complete. You must take a second educational course called a debtor education or financial management course. This course is different from the credit counseling you took before filing. Its purpose is to teach you skills for managing your money and credit in the future. You must complete this course and file a certificate of completion with the court. If you fail to do so, the court will not grant your discharge, which means your debts will not be wiped away. The case will close without a discharge and you will have to go through the trouble of reopening it to file the certificate. Once you have completed the debtor education course and filed the certificate, the final part of the process is waiting for the court to grant your discharge. The discharge is the court order that officially cancels your qualifying debts. Creditors are then legally prohibited from ever trying to collect those debts from you again. This usually happens about 60 days after your 341 meeting of creditors. The court will mail a copy of the discharge order to you, your attorney, and all the creditors you listed in your paperwork. This document is very important, so you should keep it in a safe place for your records as proof that your debts have been eliminated. It is crucial to understand that the discharge does not always mean your case is closed. If the trustee found any non-exempt assets to sell, the case will remain open until those assets are liquidated and the proceeds are distributed to your creditors. This process can sometimes take several months or even longer, depending on the complexity of the assets involved. However, this does not delay your discharge. You will still receive your discharge order on schedule. You just need to continue to cooperate with the trustee until they have finished administering your case. For most people who file Chapter 7, there are no non-exempt assets, and the case closes shortly after the discharge is granted. One of the most common mistakes people make is forgetting to list all of their debts and assets. You must be completely transparent with the court. If you forget to list a creditor, that debt might not be discharged. If you intentionally hide an asset, you could face serious consequences, including losing your discharge and even facing criminal prosecution for bankruptcy fraud. Another frequent error is making large payments to certain creditors right before filing, which is known as a preference. The trustee can undo these payments, which can complicate your case. It is always best to stop paying all debts and seek advice before you file. Finally, remember that life after bankruptcy is a new beginning. Your credit score will likely be low at first, but you can start rebuilding it right away. You can do this by using credit responsibly, such as getting a secured credit card and making all your payments on time. Avoid falling back into old habits that led to financial trouble. Use the skills you learned in the debtor education course to create a budget and stick to it. While bankruptcy has a significant impact, it is not a life sentence. With careful planning and responsible financial behavior, you can recover and build a secure financial future for yourself.